Sorry, I think there was some technical issue there. So for benefit of everyone, I'll just redo the entire thing. So coming to the EODB 1.0, it came up in 1991 during the Congress regime, and it was all for economic liberalization. The LPG policies, it was more popularly called as. LPG means liberalization, privatization, and globalization. It would just, it would enhance the capital and capital, labor, and technology beyond the national frontiers. That was the first phase of EODB. The second phase came up in 2017 when GST got introduced. And as on date, we are on EODB 3.0, 2019 and beyond, where we talk about rationalization, simplification, and digitization. How would rationalization help us? As of now, we have a plethora of acts and compliances. When we talk about rationale, they would be rational. They would be consolidated, amalgamated to have few acts or codes. Simplification is the filing and registration process would be further simplified. It would all come on the digital platform. And digitization, the authorities are working hard on putting everything online. As of now, we have most of the things online. ESIC is totally online. PF is almost there. Plus, many of the states are also making their efforts. Go to the next slide. Now, in our constitution, where does labor topic come up in? Labor, as we all know, is in the 7th schedule of the concurrent list. And the Article 43, which deals with the director principle and state policy, we talk about the living wages and conditions of a worker. And DPSP makes the state government also competent to enact legislations. So that's the reason in India, where we, the ruling party may not be have their presence in every state, right? So the state legislation, state powers to enact the legislation also holds good. Now, why labor reforms? Why we talk about labor reforms? At present, we have close to 44 central acts and more than 100 state-specific labor laws. Just the other day, I was talking to a friend in Singapore, and I asked him, how many employment laws do you deal with? He said, we have a small booklet of 113 pages, and it takes care of the entire employment laws of Singapore. That's the difference. That's the volumes we talk about. Second is multiplicity of laws leads to difficulty in compliance. There's so many laws, and every law has a stipulated way of maintaining the compliance. The definition changes from acts to act. Even the wage acts, we popularly talk about the wages act, payment of wages, minimum wages, bonus, and equal remuneration. Even in each act, the wage definition differs. So that's the multiplicity of the laws in India. Multiplicity of authorities. We have close to, we have so many authorities dealing with labor laws. The PF authority is different, the ESIC authority is different, the LWF state authority is different, PT, professional tax authority is different. Trade lines, we have to approach the municipal. The gratuity, that's again a typical case. Central ALC, who deals with gratuity matters, and is termed as a controlling authority. So that's how the complication comes up. Yeah, we all know that majority of the labor laws were enacted in pre-independence period. The Factories Act we talk about is 1948, but it got enacted in April 1947. So even that becomes pre-independence. The only two labor laws which I can see, which are post-independence, one is the Contract Labor Regulation Abolition Act 1970, and the latest one, the POSH Act of 2013. That's the reason we need the reforms. Plus the recommendation of the second National Commission on Labour, that also needs to be implemented. And there was a common request from everyone involved to come up with some reforms from the employers, from the workers, from the representative, and even from the organizations. Now let's talk about the objectives. Now, when all these laws which we are following as on date, they were pre-independence. So from 1947 to 2020, we have traveled a long way. Our economic conditions have been different then and now. So the ease of doing business then and now, there's a huge difference. So all these laws, they should be aligned with the present economic scenario. That was the main objective. Second was, of course, as we just spoke about the multiplicity of the authorities and the laws, facilitating an easy compliance mechanism. They were of prime importance. Then, of course, for a worker, it's, as we spoke, the health, safety, social security, wage security, they are very, very important. To improve and increase the employment opportunities. In states like, let's talk about the 7 queens, the 7 hill states of India. There aren't any employment opportunities. That's the reason people from those states, they travel to all these bigger cities to get employment, to earn their livelihoods. If our laws are made so effective that they bring in industries and investors into those states, then all those people, they don't have to travel so far to earn their livelihood. And most important is the technology. Now it's the technology. We all talk about technology. Why not in our labor laws? Why not in our employment laws? Technology just brings in the transparency and accountability. The ESIC and PF authorities. Previously we always used to talk ill about these two authorities. Bhai, kaam nahi hota hai. But with the digitization and technology coming in force, things have become so simple. They are questioned if a withdrawal is not matured in next 30 to 45 days after you receive a withdrawal claim. So that's the uniqueness of putting in all the technology into these platforms. Now, labor reforms. It's a two-way thing. One, the authorities are working on the governance reforms, like bringing in digitization. We have, recently, it's not recent as it is, Shram Suvidha portal, the common registration, the common return, UN, these are all part of governance reforms. They would just make the process very simple and all digitized, all automated. That's one part of the labor reforms. The second part is changing the legislations, the acts, the present acts. Though we have been tweaking the acts here and there, like the Factories Act recently got amended, the Maternity Benefit Act, Employee Compensation Act, Payment of Gratuities, all these got amended recently. But now we are looking at a bigger thing, the labor codes. The first 3 are already on the way, the code on wages, the code on social security, and the code on occupational and safety, health and working conditions. Now let's talk about the codification of labor laws. In the initial slides only, we discussed that we have close to 44 labor laws in India. So now we are talking about consolidating and amalgamating all these 44 acts into 4 or say 5 codes. And the first of them would be the Code on Wages. Then the Code on Social Security and Welfare, and thereon it will go on and on. So today we have devised a presentation that will take up each code in one of the sessions, and every next session we'll discuss on the other codes. So today we'll discuss the Code on Wages. Now, why India needs a wage code? What is the need? We all know that 62% of the workforce are casual workers, and they of course need right to minimum wage. Now, when I talk about casual workers, we all live in cities, and every city has a labor shop where every morning the casual laborers sit and wait for some prospect to take them for a dehadi, for a daily wage. Or even your domestic help, your neighborhood presswala, your car cleaner, everyone is part of the casual workers, and they also have a right to livelihood and right to minimum wage. So majority of the workforce is getting neglected. So that's the reason we need a code on wages. Secondly, the present minimum wage system is very complex. The minimum wage is fixed for only 45 scheduled employments by the central and 1709 are fixed by the states. That's the variation. And of course, 33% of our workers are still paid less than the minimum wages which got indicated in 2009-2010. So these are the 3 main reasons we need reforms in the wages or the wage structure. Now, let's see how the Code on Wages has traveled so far. It is in March 2015 that the first draft of the wage code was put before the tripartite meeting. And after number of meetings and discussions, it was also made to share to the public for their opinion. And after all that, in 2017, August 2017, the Code on Wage bill was introduced in Lok Sabha for the first time. But unfortunately, the 16th Lok Sabha dissolved in December 2017. So did the bill lapsed. But in July 2019, again, this bill got introduced as Code on Wages 2019. But it was put on fast track, and July it was put across the Lok Sabha, and August itself it got the presidential assent and published in the official gazette. So it has been enacted in August 2019. So this has been the travel of the Code on Wages. Now, Code on Wages talks about the consolidation. That was the word initially. So it talks about amalgamation, rationalization, and simplification of 4 wage-related acts, being the Minimum Wage Act, the Payment of Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. Now, what are the changes? How the Code on Wages is different from the existing acts? Let's deal with it on a one-to-one basis. So the common approach would be that, as we spoke about, each act has a different wage definition and several others. So we are trying to bring in some uniformity, that the texture remains the same. Of course, without compromising on the wage security, social security, health and safety of all workers. That's like prime factor. The wages need to be reviewed and revised at periodic intervals, not exceeding 5 years. We know there have been states where for years together there was no revision. We won't go any very far. I mean, even in Delhi, there was a period when the minimum wages did not get revised for 7-10 years. The anti-discrimination provisions are confined to gender-based discrimination only. That I don't see there is a huge difference in the existing and the proposed code. The good part is now it would be the end of Inspector Raj in India. The inspector, so-called inspector, labor inspector, would become a facilitator. Now, what would be the role of the facilitator? What is the present structure? A labor inspector comes, asks for the compliance records. If we have them ready, we present it. If we don't have them ready, we ask for a next date. He may or may not oblige us. And he slaps a notice. With code on wages coming in forward, the facilitator would not act like this. He would facilitate. How would he facilitate? He would guide us. He would impart knowledge to maintain the compliances. And then if we fail, then he'll inspect. So there is a difference. I mean, coming and inspecting the surprise checks, they would all be gotten rid of. And the inspector would be a more friendly person. He would come, he will guide us how to maintain the compliance records. He'll allow us time to, prepare the compliance records. And thereafter only he'll, come for the inspection. And the major change would be change the prosecution and penal provisions. As of now, the prosecution is very, very lenient, even the penal provisions. And they're not very strict. They're not at all strict. With the code coming up, the prosecution, there would be appellate. As of now, we don't have any appellate authority. They're coming up with an appellate authority, and the penal provisions are structured. It is not one penalty for any offense. So these are the common approach to the code. Moving to the next, the main points. As we just discussed, applicability would be applicable to both organized and unorganized sector. So organized sector, we still have compliances. Unorganized sector, we don't have any compliances. When we talk about unorganized sector, it's the Dihadi Mazdoor, our domestic help who comes to our house every day, the car cleaner, the paper wala, the press wala. That's all the organized sector. That's the constitution of the unorganized sector. Wages definition would be common. One definition for the wage code. The wage definition would not, four acts would not have four different definitions of wages. Floor wages and minimum wages. That's a new concept. That's a new concept which would change the entire ball game. Now the central government would fix the floor wages. Floor wages would be basis the living standards of a worker in a particular state, in a particular location. We'll discuss it further in other slides, upcoming slides. There would be a combined register for the code on wages. There won't be like, as on date we have, state specific, there would be 8 to 12 registers under compliances to be maintained. Right, now we'll have a combined register. They would cover all these 4 acts and it would be one register. Inspection, single authority. It is not For minimum wages, there would be a different authority. For payment of wages, there would be a different authority. Likewise, and the inspector and facilitator concept we already discussed, and web-based inspection, there would be the human interaction or interference would be minimized. I don't know how far it would be possible, but what they're planning, what the executive is planning is that the inspection would get done over the mails. The inspector would send you a mailer that I need to please upload these documents. I need to inspect your records. We revert back to them that we don't have these prepared. He'll guide us how to create those records, and then he'll inspect and close the inspection. Claims and opportunity to claim. Claim under the code will be adjudicated by the authority appointed. We have authorities appointed for claims, but there would be a appellate authority also. So it is not that once the claim is approved or rejected by the the appropriate government, you have to take the legal recourse. You still have an appellate authority within the labor domain to hear and adjudicate your matters. Now, what major changes are expected in the existing provision and the proposed provision? As of now, the minimum wages are restricted to the scheduled employments only. When we talk about scheduled employments, and fine, one is scheduled employment, the other one is controlled industry. Let's take the example for the state of UP. To my knowledge, they have the highest number of scheduled employments, and they're close to 77, followed by Karnataka, who have close to 71 scheduled employments. And rest, they would all fall under the controlled industry. That was the thing. Now it would apply to all the employees, irrespective of whether they fall in this category or not. Fixation, as of now, vests with the central and state governments in the respective spheres. Now, as we spoke about, there would be a national minimum wage. The floor wages we spoke about, that will be fixed by the central government. And the states would have their own structure. Now, appropriate government will fix what? They'll fix the minimum rate of wages depending on the factors like skills, arduousness of the work, and the geographical location. So while we're talking about the 7 states, they have minimum wages ranging from 3,300 to 3,500 per month. Whereas in Delhi, the minimum wage is more than 15,000 per month. Right. So that disparity, that thing needs to be taken care of. Moving on to the payment of wages. What changes would the code bring into us? As of now, there is a threshold limit of employees drawing less than 24,000 per month. Right. And the proposed thing is, in the code of wages, there's no such ceiling, there's no such wage ceiling, there's no such threshold limit. All employees would get covered under the Payment of Wages Act, under the payment of wages definition. And they are really thinking even to get the provisions to be extended to the central to the government establishment as well. There's a lot of strictness around the making payments. I mean, the states, the central, they insist that all the payments should be through bank, but it is not being followed in the letter and spirit. But with the code on wages, it would be strictly, any wages shall be paid strictly through bank transfers only. And what when we talk about payment of wages now, it's just the size of the organization. Less than 1,000, 7 days monthly pay days, and if it's more than 1,000 employees, it's 10th of every month. But in wage code, it will be mandatory for every employer to pay within 7 days from the expiry of the wage period, irrespective of the size. So that 1,000 ceiling has been broken through. Next, payment of bonus. Payment of bonus, it's a calculation bonus, which is in itself is it's a very complicated thing. When we talk about payment of bonus, what usually the employers do is there are exclusion to the payment of bonus, right? Like when you're calculating bonus, the HRA, travel concession, bonus already paid on like production incentives or attendance bonus paid. All these can be excluded, like employers' contribution of PF, gratuity if paid, or commission if any given to these are exclusions. But at times, I mean, as employers, we tweak it and make it to our advantage, and the bonus amount gets reduced. But now there is a ceiling, there is a limit. All these exclusions cannot be more than 50%. So these allowances have been restricted to 50% only of the total gross salary. There would be one claim authority for all claims. This goes for the entire code on wages. There would be an appellate authority, which has not been there so far. There would be graded penalty. As of now, any offense, the penalty remains the same. But now there would be a graded penalty. More grievous the offense, more would the penalty, and vice versa. This is also a new concept of compounding offenses, which has come up in this code on wages. That would really benefit the employer to the maximum. If we are able to prove our bona fide and say that fine, we are ready to be on the right side of the law, the authorities would facilitate us to do so, and they would even compound the penalties to 50% of the graded penalty. And just to empower the women more, as of now, if you are convicted under the Sexual Harassment Act, your bonus would remain untouched. But now, if in case of any conviction of sexual harassment, it is an additional disqualification. Your bonus can be forfeited. So that's a major change in the code on wages as far as the bonus is concerned. Gender discrimination, prohibition of gender discrimination. There, I don't see there's enough change in the gender discrimination. I mean, even as of now, it's like on the ground of gender. I mean, similar work, similar nature, same work by men and women, they should be paid same wages, right? And any dispute as to whether a work is of same or similar nature, the dispute will decide with the authority, right? But what I find is slightly different is that no employer shall, for the purpose of complying with this, reduce the rate of wages of any employee. Suppose Abhay is at a salary of 10,000 and Maya is at a salary of 6,000, right? They are both doing the same job, same organizations, same everything same. So just to be on the right side of the law, Abhay's wages cannot be reduced to 6,000. They'll have to increase Maya's salary to 10,000. So that's the only tweaking I see in the equal remuneration thing. How the code on wages would benefit the workers? As we spoke about, minimum wage extends to all employments. So even the domestic help, the Dihadi Mazdoor, the press wala, car cleaner, they all come under the ambit of code on wages. The national minimum wage, That would be the game changer. No state can fix a minimum wage rate below the national minimum wage. So whatever is the floor rate fixed by the government, you cannot go below that. Just for an example, Delhi has a minimum wage of 15,000, right? And they are proposing 4 factors, 1, 2, 3, 4, depending on the economic and socio-economic scenario in the state. They would factorize the NMW. So if it's 4, say we divide 15,000 by 4, so it comes to roughly 3,750 rupees. But as we discussed, in states like Manipur, Meghalaya, those 7 queen states, the minimum wage is already 3,300, right? So they'll have to increase the minimum wage to 3,750 at least. So that will be the advantage, disadvantage, we'll talk later. Provision of timely payment of wages, it has been fixed at 7th, and regular deduction extended to all workers. We discussed that. Payment of wages through banks, strictly through banks, no voucher payments, no cash payments. The loading of remuneration allowances excluded for calculation bonus, so at that ceiling of 50%. You cannot have exclusions beyond 50% while calculating the bonus for the employee. Again, the deductions should not exceed 50% of the employee's total wages in the period. Now, this is very important. Suppose, due to negligence, I have caused damage to the employer's property or person, and the total damage amount which is recoverable from me is 50,000. I am at a wage of 10,000. So it is not that the employer has a right to not pay me for next 5 months. What he'll have to do is he'll have to pay at least 5,000 rupees every month, and this period would get stretched to 10 months. So 50% of the wages I'll get, and 50% gets deducted each month. So the damages recovery period stretches to 10 months instead, right? So these are the benefits to the workers. Now, how would it benefit the employers? At the beginning only we discussed that employers just look to ease of doing business. That is what they look for in the employment laws. So Code on Wages brings in the transparent inspection scheme, which would reduce the arbitrariness and discretion. Now we are at the mercy of the authorities, of the labor inspector, Even if we have all the records in place, he will still ask for something which may not be possible for us to maintain. Right? It's like, the traffic police. I get on the road, I drive, he stops me. I furnish all the documents required. When I've shown all the documents, then I get a remark, "Sir, aap gaadi bahut gandi rakhte ho." So that's a similar mindset every authority has. So even in case of labor inspection, even when we furnish all the required documents, they'll ask for something which would not be available with anyone, So with the inspection getting transparent, it would definitely, that discretionary power of the inspector would get zeroed out. The provision of graded penalty, that's a very welcome initiative, and compounding offense. These two are very welcome initiative for the employers. As of now, any offense, same penalty. There's no compounding. Even if whether my intentions are right or wrong, there is no leverage. Because even the law says that it all depends on your intention, the mens rea. Even I have the right intention, maybe negligence or whatever, I could not. But it does not, tantamount to, it cannot be equated to a malified intention when I don't intend to. So compounding offense, great penalty, they are welcome initiatives. Compliance notice before prosecution, except for grave offenses, of course. So there would always be a notice before prosecution. It is not that the inspector record and slap court notice. So there would be a compliance notice. And every employer would be given time to make good the non-compliances. Facilitators in place of inspectors, as we discussed, it would be the end of Inspector Raj in India. We trust it should be the end of Inspector Raj. Simplified common electronic registers and returns. There would be common electronic registers and returns. But surprisingly, something very interesting. Few of our progressive states, they thought about they have been tweaking their labor laws from time to time, and all praises for the government of Haryana. Government of Haryana in their labor policy in 2006 had given the leverage to the employers to maintain their records electronically. That point in time, most of the other states, if you intend to maintain your records electronically, you have to obtain a ERP from the labor authorities, electronic records permission. So Haryana thought about the entire thing, and they introduced this in 2006, way back in 2006. Likewise, when state of Telangana came into existence, there was a blanket thing, for any approvals, registrations, renewals, you apply with the authorities. If they don't respond within next 15 days, it is deemed granted. So that is the kind of simplification employers were looking for, and which is being given by the Code on Wages. There would not be any difference in the size of the establishment as far as the compliance requirements are concerned. If a small time business has to maintain the same and similar kind of records as an industry employing 50,000 workers. Breach of limitation period, that is very important, could pose administrative and economic burden on the employers. As of now, the limitation period, there was a lot of ambiguity around the limitation period. It would range between 6 months to 2 years. Now the limitation, it has been to our favor. The limitation period for any breach has been enhanced to 3 years. So there's no variation. It's 3 years straight away. And minimum wage needs to be reviewed and revised at intervals not exceeding 5 years. So such previous lapses will be taken care of. So every 5 years maximum, the minimum wages needs to be reviewed and revised. So these are the the benefits which would be in offering for the employers. Now, what is national minimum rate of wages? That's, the other name is national minimum wages or the floor rate, right? The central government would fix the national minimum wages. We just discussed about the how the calculation would work. Delhi and Manipur, Meghalaya, 15,3750, right? So in lieu, taking a cue from that, the minimum rate of wages fixed by the appropriate government shall not be less than national minimum wage, right? So if the national minimum wage has been fixed at 3750, even Manipur, Meghalaya has to, keep it at 3750. They cannot keep it at less than 3750. If the minimum rate of wages fixed by the appropriate government earlier is more than the national minimum wage, then the appropriate government shall not reduce. So that's what I said. They cannot reduce it to 3,300. They have to increase it to 3,750 only. So yeah, we will discuss later how it would impact the states with lower minimum wages. Yeah, responsibility of the payment would always remain with the employer, but now the code on wages comes with a very firm and strict regime that if the employer fails to pay, it would become a personal liability of the company, firm, proprietor, owner of the establishment. So it's sort of a personal liability of the employer to pay the wages or bonus or whatever is due. Claims under the code, yes, there would be an authority appointed to hear and determine the claims and direct for payment. The claims, all such claims, if not adhered to, the orders are not adhered to, then the authority shall issue recovery note certificates to the collector or the district magistrate. And who all can file the claims? An employee can file the claim. He can file a claim through the registered trade union, the trade union is registered with. The facilitator, if the employee, tells the facilitator that this is the problem, even the facilitator can file a claim on his behalf. And as we mentioned earlier, the limitation period has been increased to 3 years. Earlier it was between 6 months to 2 years. There was a lot of ambiguity. There was no fixity as such. So that's about the claims under the code. Burden to prove. Wherever there is a non-payment or less payment of wages and bonus, the burden to prove that the payment has been done would remain with the employer. If the employee claims that he has not been paid or paid less wages or bonus, it would be on the employer to prove that no, it has been paid. Right? So it removes all the ambiguity around the payment part. Now, appellate authority. This appeal is a new thing which is getting introduced in the code on wages. So if a claim authority has made a decision, it can be appealed to the appellate authority within 90 days. So the limitation period is 90 days. And it would be a fast track kind of a mechanism. And the appellate authority has to dispose of the appeal in next 3 months. Right? So coming to the next important thing, the facilitator and the web-based inspection. We discussed it earlier. I will run through it again because it's very important. It would benefit the business the maximum, I suppose. So now they are introducing a concept of inspector cum facilitator. And for all these 4 laws, the code on wages, there would be one inspector cum facilitator. Earlier, for different acts, there would be different forums, but now they are unifying everything. So one inspector cum facilitator for all these 4 laws. He would be, what would be his responsibility? He would be responsible for inspection of the establishment, of course, but he would be an advisor to the employer and that employee for better compliance. Suppose if I err somewhere, he would give me that knowledge or the understanding of the compliance which I lack. And then if I again commit a mistake, he'll again guide me. So he would be imparting knowledge and guidance to both employer and employee for better compliances. And when we talk about inspection based on web-based, it is, as we discussed earlier, it will be all done over the mails. The inspector would, send us an inspection notice over a mail and ask us to furnish the desired records. When we furnish the desired records, we upload the records and send it back to him. He'll inspect the records and share his observations. Wherever non-conformity, we would have given enough time to make good those non-conformities, and thereafter the closure would be done. So that's the reason this facilitator word has been attached to the inspector. Going to the next slide. Cognizance of offence. I mean, it's very related. No court shall take cognizance of any offence punishable under this code, save on a complaint made by or under the authority of the government or an officer authorized in this behalf, by an employee, a registered trade union where he is a member, or a facilitator. Right? So we have appropriate authority, then we have the appellate authority. If both the doors close, then we go to the civil code or the criminal code as the offence directs us to. Offences and penalties, we discussed. I mean, all the offences are clear and even the penalties are all graded. When we talk about the offences, either it would be non-payment or less payment of dues of the employees. It would be non-maintenance or improper maintenance of records, compliance records, or any other contravention of the code. So what are the penalties levied to these contraventions? Code has discovered all offences. Now, interestingly, under CLRA, when we, in case of any non-compliance, and if it reaches the code, it is straight away sent to the criminal code. The CLRA matters are being heard by the CJM, the judicial magistrate, right, under the penal provisions, right? So all these would be decriminalized, except recurrence of similar offences within 5 years. So there is a threshold limit of 5 years. If similar offence gets committed again within 5 years, then it may have a criminal route. Maximum penalty. Maximum penalty is imprisonment for 3 months and with a fine of 1 lakh, rupees 1 lakh. Compensation claimed by the claimed would be 10 times, can be 10 times of the claim. And again, as a graded penalty for not maintaining registers is 10,000 rupees. As of now, there is no clarity. As of now, we don't know. I mean, if I don't maintain a register, what would be the penalty? But now it's all graded. We know the maximum fines. We know the fines for the non-maintenance of records and fines for dues not being paid. Compounding, again, a new concept which is coming in, and it would benefit the employers and employees to the maximum. At any point in time, before or after initiation of prosecution, I can approach the authorities and express my bona fide. And the offences will be compounded, and maximum fine, whatever the maximum fine, we might, I mean, at his discretion, we just may end up paying 50% of the maximum fine prescribed. But there is again a rider, once compounded, we will not be permitted within the next 5 years for the same offence. So it coincides with the penalty code as written, except recurrence of similar offence within 5 years. So these are same thing. These are similar things, you know. They just complement each other. So compounding would really help the business fraternity to grow and with less hassles. Now, so far we have been only speaking about all the what benefits it would bring into the employer and the employee and the exchequer, of course. But we would also like to share few insights to the code on wages, where we see, I mean, all the entire presentation, the contents have been prepared without prejudice based on our knowledge and understanding, right? So we may not be correct always, but these are our insights. This is how we look at it, right? So we all know that post GST, the implementation of GST in 2017, the capacity of the states to attract investment on the basis of low wage rate. Again, when we talk about low wage rate, we look at those seven queens, those 7 hill states. Why the wage rate has been kept so low? Because two major factors. One, it is they are very close to the border, demarcating China and India. So there's a lot of interference in their daily activities. And secondly, no investor or industrialist is trying to invest there. Right? When the GST got introduced, as it is, they have taken a hit. They're still trying to come out of it. And now, if this thing comes up, the code on wages, and remember the example of 15,000 and 3,750. So they'll have to again increase the wage rate. So that would further complicate the financial hurdles for them. And believe me, I have traveled from West Bengal to Sikkim all by road. And believe me, I just came across two industries there. One was the YY noodles and another brewery. Unfortunately, both the industries were owned by none other than famous Bollywood actor Danny Deshangappa. So that's the, he being a local lad, he could, whatever earnings he made in Bollywood, he invested there. Rest, you don't find many industries there. So that's one part. Second, organization would remain in the informal sector, where policing wages is difficult. Suppose I, being a legal person trying to be on the right side of the law always, the domestic who comes to my house, I stick to it that I'll pay the minimum wages. But she spends just 1 hour in my house. She goes to 10 more houses. I cannot ensure whether the others are the minimum wages, as per the minimum wages or not. And who would maintain the records? How would the monitoring be done? What would the structure for social security? Would she be paid PF? Would there be deductions, contribution for PF, ESIC? Would she be given bonus? So these are the things. So, the unorganized sector, in the informal sector, they would try to remain in the informal sector only. Third, once the minimum wage will be applicable, all classes of worker would certainly make it more difficult for smaller companies to function efficiently. A small-time businessman who runs an office has kept few office boys. I'm taking a case in Delhi, say Delhi, where the minimum wage is 15,000. But the office boys are just paid 6,000, 7,000. Right? If this code is followed on letter and spirit, would that small-time businessman be able to survive if he pays 15,000 to that office boy? Where in the same office, to the executives even, he is paying 12,000, 13,000. So that will be another challenge. And of course, as our Indian mindset goes, our unorganized sector will eventually find ways around to bypass the law if economic tells them they can't afford it. That's for sure. Before the law gets enforced, we always have a way to tweak and turn it our way. That's how the Indian mindset works. And last but not the least, implementation of the codes. The codes got implemented in August 2019. We are in 2020 April. But what has been done so far? The central government is still struggling to frame the rules. To the extent they're still struggling on the national floor wage rate. They are still to define and make out the national floor wage rate. Suppose it all gets done eventually. It all gets done. how would they implement it practically? Would there be a parallel? Or they will just say from tomorrow the code on wages would prevail. All these 4 acts, they're repealed. But that would be very difficult because, we are maintaining the records as per the existing acts. So we cannot, just turn around and start with the new regime. When our railway bookings got automated, computerized, they used to run it parallelly. For close to 2-3 years, the system went parallel. And finally, it's all digitized now. It's all automated. It's all on computerized. So these are the challenges which we see on implementation of the code on wages. I think I'm done with the contents we had, the discussions I had to, all the points I had to discuss with you all. I would like to thank you all for lending me your ears and